I will get started. We have lots of stuff to cover today, and so I wanted to get going with this. But this is one that's going to be a I was going to say a fun one, and then I realized that estate planning isn't really a fun thing to talk about, but it's a very important thing to talk about. So what I'll do is I will be going through and just setting up a little bit of a short introduction, and then we're going to be handing it over to some of our guest speakers to speak. As I wanted to make sure that we get a financial planner and a lawyer to discuss a little bit more about some of the nitty gritty details that you need to know when you're looking at estate planning. There's a lot of things to consider, and it's frankly it's a little less actually about the mortgage and the financing setup. There's going to be a couple of things that are really useful and important, of course, on that note. But for the most part, it's actually really more of a legal and financial planning type of conversation that you're wanting to have. So let's get into it. So if we're looking at the estate planning side of things, a lot of aspects, a lot of things to look at here. But really what it comes down to is making sure that you have the right strategy, that you have the right setup, and then making sure that you have the right solutions for you. And the solutions for you are going to vary depending on your strategy and your setup. So there's a lot of things to look into and dial in. One of the things that is really important here, and when we look at the strategy component, this is where Christian Dye, who is a financial planner, would be able to go into a lot more depth and detail about, how exactly do you handle the strategy part of things? What are the things that you need to think about, to consider? What is your objective? How do you make sure that you get to a point where, if a situation was to occur, that the estate is set up properly? And so I'd love to introduce Christian Dye, who will be able to take over. So, Christian, I will pass over the remote control over to you. And so now it looks like you should have control over the screen now to be able to do that. If you have any issues with moving the slides, then just let me know. But Christian, maybe I'll let you take it from here.
Sure. Thank you. Kyle, can you hear me okay?
Yep.
Perfect. I believe I can switch it. Kyle, I'm assuming after my section, you'll be able to switch it back.
Yes, that's right.
All right. So thank you, Kyle, and thank you for everyone for listening. So a quick brief introduction. My firm is called Latitude West Financial. We're a traditional financial planning firm, but we specialize with real estate investors. So the majority of our clients have real estate wealth, and of course, they're trying to figure out how to minimize. Usually, they want to figure out how to grow it, which is something that we do. But then the second problem is, how do we minimize taxation? How do we pass this wealth on to our kids? So a couple of books that I have out. One worth noting is Priced Out: How Will Our Kids Buy Their Own Home? And the reason why in this book there is a lot of arguments as to passing the real estate wealth on while living. And the number one reason is, if you're worth a fairly large amount of a portfolio, let's say you're going to leave each child $1 million, when you pass away in your 80s, they're in their 60s, they could probably use that money when they were in their 20s and 30s trying to buy a home. So that one over there is unfortunately soon to be released. It's almost out. For those of you who would like something, there is an ebook with a QR code near the end, which is a downloadable free ebook, more or less an expansion of what I'm talking about now. So get your QR code ready. So I want to kind of dive right in with some statistics. Only about 15% of Canadians actually have an estate plan. Now, that's not a will. A lot of us have wills. And if you don't have a will, then you should get one. And I know that there are some lawyers joining us who can probably talk to you about that. But from my perspective, estate plan is a little bit different. And a lawyer can absolutely help with an estate plan as well. But my role as a financial advisor is to kind of help with the strategy, kind of the architecture. Think of it like building a house. When you build a house, you've got, an electrician, you've got a carpenter, you've got a plumber, but you also have an architect, someone who's kind of overlooking at everything. They're actually the one on the front line sitting down with the client, talking, well, how do we want to build this? So very few people have it because they think that they're basically they think their will is enough, you know. And so when I do estate planning, I typically the majority of my clientele, it's not only estate planning, but it's estate planning specifically with real estate assets. And that's how it's a differentiator. Because a typical estate planner, sorry, a typical financial advisor who is dealing with that type of client, oftentimes the solution is, you know, when you pass away with your real estate, what you want to do is you want to, when you pass away with your real estate, you can maintain it or you could liquidate it. And if you liquidate it over here, here's the tax bill you're going to have, and then here's all of this cash, and you and your kids, you know, your kids or your grandkids can do with what they want. But oftentimes, with real estate investors, they actually don't like that. They don't want anyone to sell the real estate that they built so hard. They actually want there to be more of a stewardship of the real estate. So in other words, how can we minimize the taxation when it's passed on? Then instead of, you know, all the beneficiaries saying, hey, I'm now worth millions of dollars, now they're saying, hey, I'm responsible for millions of dollars, and what do I do with it? And that's where the estate planning comes in, because oftentimes the person who's creating this, the parents or whoever, they assume that that's what they're going to do. But with no estate planning over here, then that's often not what happens. And then of course that triggers a massive tax bill. Plus you can get pennies on the dollar on an estate sale, fire sale, real estate. So those are kind of, you know, the bad things that end up happening. So real estate makes up over half of Canadian net worth, and there's going to be this great wealth transfer of over $2 trillion. But here's a big question, especially if the people who are listening right now are the people in the scenario where they are passing on a significant amount of real estate wealth in the form of, you know, condos, houses, multi-units, not just your own home, but actually rental real estate. Excuse me. Sorry. Hello.
Got something in your throat? I've been there before too. Can't talk. Take your time.
Super sorry. Eating peanuts right before probably wasn't the best idea. Oh my goodness.
Okay, never mind. That's all on you. I felt sorry for you until I realized you had peanuts before you joined a webinar.
Oh my goodness. Oh my goodness. Okay. Let me try this again. Are you leaving a gift or are you leaving a burden? And if you're leaving a gift, that's what it should be. Here's wealth. You don't have to worry about your finances. I'm giving you a head start, or I'm giving my grandkids a head start. Now, are you leaving a burden? Burden might be, we were already leading comfortable lives. You've passed away and passed this $20 million portfolio to us and told us to steward it. We don't know what we're doing. Now, all of a sudden, you've just given us a part-time job, which you just told us not to sell. It says it in your will. It says it in your wishes in your will. Don't sell the real estate. Okay, well, we got to take care of this. Oh my goodness. On top of raising kids and grandkids and all this other stuff, now I have to manage, and I've got people calling me and decisions to be made, and, you know, tenants and toilets. So this is why estate planning is so important, because I work with, you know, a lot of widows, to be honest, where they're like, I want to honor the legacy of my husband who's passed away, but I want to protect my sanity because I'm going crazy. I don't know what to do with a bunch of these things. They're, like, I'm dealing with a problem every single day. So now this is where estate planning comes in. This is where the really deep stuff comes in. Really quick story over here. You know, $20 million portfolio was passed down. There was a sudden passing, and all of a sudden the family didn't know what to do with it. It was the husband who had passed away, who had built the real estate portfolio. But the wife and the kids just really were not equipped to manage such a complex portfolio. So then they went to a financial advisor, and the financial advisor says, it sounds like you don't know what you're doing. It's driving you a lot of stress, and you want to cash out. And then they said, yeah. So he says, well, here's what we do. We liquidate all of it. Let's involve the realtor, liquidate all of it. Realtor's going to be happy liquidating all that real estate. Financial advisor is going to be very happy. $20 million of real estate assets now going into assets under management under his portfolio. He's going to be happy. Now, the one person who's probably not going to be happy is the guy who built it, the guy who's already passed away over here. See, because the one problem, and this is a real scenario over here, there was a significant amount of taxation that had to be paid because the real estate, had to be liquidated over here. But even more importantly, it was a bad time to sell the real estate. And when we calculated it, if they would have held on to the real estate for about 5 more years, they would have had another $10 million of growth. Okay. So that would be kind of an example of a problem. But then when you think about this being a burden, what are some high level decisions that your heirs might not be equipped to handle? So a really quick case study. Imagine you have a $3 million building that you suddenly inherit. It's got $1 million of debt in it. It was depreciated to 500,000, which means if they were to sell it, there'd be $2.5 million of capital gains. The vacancy is really high at the time, 30%. The rental market is really low, and a bunch of the units need a lot of work. The property manager says, to get these units rented, we need another $100,000, and we got to improve these units over here. He says, well, I don't have $100,000 liquid in order to do these units. Realtor comes in and says, the market's low, but right now, if we sold it, we could probably get about 2.4 million. So automatically you got this $600,000, loss of value, but they don't have that 100 grand over here. So the challenges are there's no liquidity. They don't have experience with renovations, but at the same time, let's just do nothing. Well, if they do nothing, they're losing $5,000 a month in rent. So, which might not be able to cover their other expenses. So here's the quick question. Are your heirs able to handle this question? Are your heirs able to navigate through this? And that's where the estate planning comes in to figure out if the answer is no, but you want to keep it, well, who's going to manage it? Who else do you got to get involved? So that there is sort of a case of, what might some various different things if we don't have a strategy in place. And then on top of that, there's siblings, spouses, and conflicts. And this over here, it kind of it goes from bad to worse. Now you've inherited this real estate, and you do something as simple as your will. It says just leaving all the real estate to my kids and just divide it by 3. Okay. Now you've got, let's call it a $20 million portfolio, and right away the families are like, hey, a third of that's mine. How can I get that money? Then you've got some other ones who said, well, there's going to be a high tax bill. We should preserve it. Or someone says it's a bad time to sell. Someone says, well, we kind of want the cash now. All of a sudden, you also now get spouses involved who are not even part of the bloodline of the family saying, how can we get more of that? Or we deserve more. And then all of a sudden it turns into a little bit of a nightmare. Now, the good news is there are some lawyers who are coming on who could help to sort of guardrail some of those things. What I do is I architect to figure out what are we doing with the real estate. And then I help to guide the lawyers to say, this is what their intentions are, or we're going to preserve it. And then I help to communicate with the family to say, here's the game plan. And if you don't like it, they're still living. Go ahead and have a conversation with them. So right away, this kind of sibling spousing conflict is another layer of why an estate plan should be in place now. An estate plan is a series of conversations in order for us to get us to where we need to go with the lawyer and the accountant. It's figuring out what to do with the real estate and the intention of the real estate. The best solutions are while you're not only still here, but you're fully capable of making these decisions. This isn't a problem that people in their 70s should be dealing with. This is a problem that everyone with real estate should be dealing with. So the reason why this is personal for me is because I have these 3 daughters and I've got a wife. None of them can manage the real estate that I've built right now. It is quite active, even though I have all these property managers, but there's some very, very high level decision. I have no doubt that this will be a burden more than it will be a gift, but I also am the guy on my deathbed who's going to say, don't sell the real estate. So I have to come up with a plan. What happens with kids when they're young? they get older. My kids are now part of this plan. They're part. I'm now cherry picking to see who is going to be most involved. And so, what I did was when I started working on this problem with my own family, this turned into my ebook. And my ebook is called Hold, Hire, or Cash Out. And this was actually written this year. It's not a very long book, but it's essentially a family's guide to inherited real estate decision making. Who will manage the real estate? Who should I transfer any of these properties while living? How can I maximize the gift and minimize the burden? And of course, whose advice can you trust? Okay. So it's kind of like a playbook for people to read, to understand, and also see what are your options on how we could, minimize the burden. So what are some next steps over here? One, get organized. If it's you and your spouse, have a conversation. Says, well, what do we want to do with this? My mother and I and my father had the same conversation over here. And right now, a huge chunk of some of the equity, they actually want to layer it down to the grandkids. They actually don't want the kids to have it. They want to layer it down to the grandkids. How is that going to work if all of the kids are still minors right now, right? Do you need a trust in place, or is it the executor's job with a lot of conversation with family? Get professional help beyond just the lawyer and the accountant. Get a financial advisor who can help to architect this. And then once it's all set, have a big meeting and talk to the family. Let everyone know what's going on. That's the formula, so that if there's any dispute, you could talk to the people who built the wealth, whose money it is. So my financial practice is built around wealth management and real estate growth strategies. We're very pro real estate. We work with a lot of we work with a lot of people that are trying to grow their real estate wealth. We're able to find off-market deals. We're able to grow passively or actively. The one place that makes us also very unique is real estate asset management. If there was a family that suddenly inherited real estate, or if you were planning on inheriting real estate, and you want two things: one, you want to maintain the real estate, but two, you want to take the burden off the family. Our team could actually manage the real estate for you if that was something that you were interested in, or make those preparations if that's the way you wanted to will it. We're a fee-for-service practice. That way our fiduciary duty is to you, not to buy or sell any form of real estate. We're based here in the Lower Mainland, but of course, we're national, and we work with clients all across Canada. I'll just going to leave this up for a few seconds. If you wanted a copy of the ebook, it'll be uploaded in probably about a month for sale, but right now we're just giving it away for free. If you scan the QR code, get a copy of the ebook. If you don't have your phone on you and you don't have an opportunity to, you can just email us and then we'll send you a copy of it. So, hold, hire, or cash out. It's a good playbook for you to read, you and your spouse to read, to try to figure out. If you've got parents who are about to pass down some real estate, it's a nice way to kick it back up to them as well. So then they could say, hey, read this. It's kind of a bit of a, here are our options and here's some things to consider. I want to be mindful of time, Kyle, just because I know there are other speakers over here. I'm just going to leave this up for a second as well. If anyone wanted to connect just to talk a little bit more about your situation, this QR code is to kind of set up a meeting with us, or you could just get my email and our website. But more or less, I hope that's been of value to you guys over here. Get organized early, start getting professionals involved, and then start having that conversation, because you never know what might happen. But many people like to hold on to their real estate, and of course, we want to pay as little tax as possible.
Awesome. Thanks, Christian. I appreciate that. A couple of things that I picked out from your talk here was an interesting concept of the stewardship. And actually, I feel that, and I know that, but it's interesting to go through that process and see that the people that have built this empire don't want to just say, hey, here you go, do whatever you want with it, sell it all if you want. Like, they want you to maintain and continue the legacy of that real estate portfolio. I think that's a understated thing. But then what that creates is it can create the situation where, great, you have all of this asset value, but you actually have a liquidity problem in many cases with a lot of these investors who are very heavy on the real estate side and light on the liquidity side. And that example of, okay, now you've got this property and it hasn't really been well maintained because your 80-year-old father wasn't really managing the property. You have to put more money into it in order to improve it. And I'm thinking about this from the financing perspective. If a buyer is trying to buy that underperforming asset, they won't be able to get sufficient financing for it. So then the only price point that they could pay might be that 2.4 million instead of the 3 million, right? So it's interesting thinking about how the process could go. And I think the lack of liquidity, especially with a lot of investors who have large real estate portfolios, is one of those issues, especially with the stewardship of maintain this, but I don't have any extra actual cash to give you. It's just the real estate equity, right?
Yeah, that's great. And the thing is, that's where you come in so well, because you think if you work with like the financial advisor like me, a lot of times I'm sending them back. It's like, don't sell it. You're going to get pennies on the dollar. Don't say, yeah, but I don't have the 100 grand. Let's bring in Kyle. Let's see if we can take a HELOC. Let's see if we can do a chip mortgage off of another property. Let's hold on to this thing for dear life until it recovers. And then there's all these strategies on to pay that back. So even if you're, accumulating interest, the interest cost off of a couple of years might be nothing compared to the lost value up front. But it's so many of them cannot make that decision. They don't have the ability for the cost benefit, and they don't even know the options. Oh, I didn't realize I could take a chip mortgage out of, my aunt's home in order to cover it, and I'll pay them back in 3 years. Like, there's all these different scenarios that they didn't even realize were there because they weren't working with the right professionals.
Yeah, exactly. Awesome. Thank you. So I will take control back, and I'd like to introduce our next speaker. So I see Rick, you're here, and then is Evan joining us as well?
He should be.
Yeah. Okay.
I'm here.
Awesome.
I'm here.
I'm surprised with my technological ability. I'm surprised I'm here, but
Fair enough. Yeah, good. And so I'm going to give the control. Actually, I don't know. It's not giving me the option to give control. What I'll do is I'll just move the slides for you, Rick. So I'll slide it around for you guys, and I'll let you talk. Thanks, Christian, for being on time. I know that we have 3 people that all like to talk. There's myself, Rick and Evan, and then of course Christian. So we're going to do our best to try to stay on time here and give you guys the feedback that you're looking for.
Kyle, it's impossible for us to be on time. That's not going to happen.
I know, right? Yeah.
So Evan, are you on?
Can everybody hear me okay?
Yeah.
There you
Excellent.
go. He is there.
Perfect.
So
All right.
that was excellent, Christian. And actually, Christian and I, we have to have some discussions because he said a number of things that I've got a few clients that I think are perhaps going to need Christian's help. So Christian, if you're still there, you and I should probably talk tomorrow.
Absolutely. Would love to.
Yeah. So Evan and I, we're going to talk about some legal kind of planning here vis-a-vis estate planning. If you look on our slides, we've got an agenda that has 6 items on it. So Evan is going to talk about the first 2. I'm going to talk about the middle 3, and then he's going to finish off with the last one, number 6. So Evan, why don't you introduce Letting and Company, and then get into wills and estates planning.
Sounds great. So we're Letting and Company. We're a real estate focused boutique law firm here in Vancouver. So we're what you call a solicitor's firm. We don't practice litigation, but we have a healthy real estate practice development from conception to sales to dissolution of companies. So we handle the corporate side of things, everything real estate, and we also work on planning for our clients as well. So estate planning, and there's a couple key instruments that we use in creating a plan for people on what happens on the next step in our journey. Next slide, please, Kyle.
Yeah. Oh, hold on. Where is it? Why is it not moving? There you go.
Perfect. So estate planning matters because, and we get asked this all the time. Well, what if I just, what if I don't have a will? What happens? And, we'll get to that in a second. But estate planning is important because it allows you to control what happens after you pass away. You can, within the confines of the law, decide what happens to your assets, who they go to, and you can minimize taxes and fees, within reason. You can protect your loved ones. You can make sure that your assets are going where they're intended to, and not just where uh, the default kind of legal setting an intestacy would allow. Um, there's also avoiding disputes. So, um, one big part of estate planning is trying to provide certainty, and whether that's naming an executor or naming beneficiaries under your will. It's about trying to provide as much certainty as possible to provide control to your executor, or provide direction to them, so that there isn't disputes about who's getting the family cabin, or that prized piece of artwork. Business continuity. So if anybody's a business owner, um, having a will and giving authority to your executor in that will, or having a power of attorney and making sure that your attorney can um, continue on with your business affairs is really essential. And then it just all comes down to peace of mind. Um, you know, when we put a plan in place, a big part of having an estate plan is is about those who we care about, because we'll be dead. So having a plan in place generally makes it easier for those who we leave behind, which is generally something that most people want. Because when somebody passes away, you have to deal with the emotional side of things. So if you can streamline the legal and financial decisions as much as possible, then that's a huge gift that you can give to the people that live on. All right, next slide. So the next slide is what happens if you don't have any will in British Columbia. And one misconception that comes up often is that if we die without a will, the government gets everything. And I'm here to tell you that's not the case. If you pass away without a will, the Wills, Estates, and Succession Act, or WESA, as it's sometimes shortened, sets out a scheme for what happens with your assets if you die intestate, or without a will. And for most people, if they have a spouse, everything gets split between their spouse and their children. There's a preferential share that goes to a spouse, and then everything else gets split 50-50. Now, when you first think about that, that seems fair. Okay, I'm going to give everything to my kids, my spouse, they're going to split it. So, great, right? Well, not necessarily, because most people who do a will that are married end up gifting everything to their spouse, and then the last of them, or their spouse to die, everything goes to their children. So, we've got an example here. We had a client who married their high school sweetheart, and he unfortunately when he was still middle aged, he unexpectedly got a very aggressive form of cancer, and he wasn't able to do a will before he passed away, and he had a company that was worth about $4 million, and him and his wife had, their plan was that if either of them were to pass away, everything would go to the surviving spouse, and the surviving spouse would manage everything until the last of them were to pass away, because they had kids that were 19 and 20 at the time. And Unfortunately, before this gentleman passed away, they weren't able to do a will. And he passed away, and this company of considerable worth was due to be basically split between his wife and his children. And, the kids were beside themselves because they just lost, their dad, probably their heroes and one of the most important people in their lives. And now they were set to inherit a company that was, worth several $1 million, along with their mom. And they were in no position to make any kind of decisions. And their mom was struggling as it was, but she was, she had a good head on her shoulders. So, in that case, intestacy didn't make any sense at all because, we had two kids here that they just weren't equipped to run a business with 100 employees. And ultimately, at the end of the day, if the will had been put in place as intended, um, they would have received everything when their mom passed away. The last of their parents were to die. So, fortunately, here the kids, they worked with their mom and they said, look, you know what, we would we want everything to go to our mom, and and then when it's her time, then we will inherit the business and take things from there. So we were able to deal with that. But if they hadn't been in that right headspace at the time, it would have been a much more difficult situation. So having a will in place there would have definitely would have made things easier. Because the other thing to keep in mind is when you have a will, you can name an executor. And generally, when you name an executor, that person has a right to go and get a grant of probate and deal with things in your will as you set out. Whereas if you don't have a will, then you have to apply to the court to be an administrator. And depending on your financial background, the court might need a bond or they may need consents from other people. Um, so it's definitely a more streamlined process to name an executor in a will. Um, Also, the distribution scheme, who is getting what from your estate, is set out in the Wills, Estates, and Succession Act. So, if you had intended for any part of your estate to go to charity or somebody that wasn't a blood relative, then you're kind of stuck. So, um, and generally, if the only people that you have to provide for are spouses and children. So if you don't have a spouse or children and you don't want things to go to your siblings or your parents if they're still around, if you're to pass away, then you definitely want to have a will, because that's sort of the default that the government has in place with intestacy, is that it goes, that your assets go to your family. So, while intestacy isn't the end of the world, the government generally doesn't get all of your stuff. um it's imperfect, and it usually makes things more difficult for those who survive you. So that is why a will is essential. um so then there's a couple key estate planning documents. So a will is probably what most people are familiar with. And to take a step back, a will is what happens with all of your assets when you pass away. You can name guardians for your children, and you can appoint an executor. So there's some key things that you would do in a will. It's very important. It comes into place when you die. But almost as important is a power of attorney, because um, and these often come into play when you're still alive, but maybe you have incapacity, or maybe you're out of the country and you need to make decisions, or you need somebody to sign things for you. That's where a power of attorney is essential. Um, and most commonly, the power of attorneys that we do are what we call enduring powers of attorney. So they're in effect from when you sign them as the person giving authority for somebody else to do things for you, and also when that person has signed. So when the document is fully signed, then that person can make decisions for you. Now, they usually have a fiduciary duty to make decisions in your best interest. So they can't just, take money out of your bank account and self-deal. But there's another type of power of attorney called a springing power of attorney, which springs into force when somebody loses capacity. And those kind of powers of attorney, we actually don't see them very often. And the logic there is that if you don't trust somebody not to use that power of attorney when you have capacity and when you can oversee what they're doing, do you really trust them to make decisions when you don't have capacity? So, and it's also you have to get statutory declarations from doctors and other people to give that springing power of attorney um, action and put it into force. So, and typically if somebody is in a car accident and they need to sell an asset, usually you don't have the luxury of that kind of time to go around and see doctors and get statutory declarations. So, especially for those people who own real estate, an enduring power of attorney is typically what we see with the um, as an estate planning tool and something that the land title office recognizes. So, um, and just as a quick story, we had a client who had a power of attorney. They'd actually had the foresight to go and get a power of attorney for their mom, and their mom ended up getting dementia, and it was and they had to sell a property that they jointly owned, our client and her and his mom, to fund her care. And they didn't have the original power of attorney. And the consequence of that was that they had to go and get her committed. So they had to go to the court and consult with the public guardian and trustee and get her committed. And it was it basically, this was in, around COVID when, real estate was really hot, and it ended up causing the sale of the property to be delayed. And of course, the sellers didn't grant an extension for nothing. They wanted a discount in the purchase price, and while our clients went and got their mom committed and got authority to manage her affairs. So um, it was quite a process. So and it's the same if you don't have a power of attorney and you need to make decisions for a loved one, especially a loved one that owns property, is you have to get them committed at the Supreme Court. And it's a $10,000-$20,000 application when you include legal fees and court costs. And it involves extensive monitoring and disclosure by the public guardian and trustee. And all of that can be avoided by a power of attorney that is executed properly and kept in a safe place. And now the one consideration with the power of attorney, one big consideration, is that you have to do it when somebody still has capacity. So when they still have that mental capacity to grant that power of attorney. So, it's almost as important as the will to have a power of attorney in place, especially if you own real estate. And then one of the other key estate planning documents in our toolkit is the representation agreement. And this document is also important, especially for people that have very specific wishes about their healthcare decisions. In the United States, a similar document is often called a living will. Here we have something that's kind of more similar to that. We call it an advance directive, but we don't see those very much because they're not dynamic documents. If you put your wishes, say, for example, regarding do not resuscitate orders in a document, if it's set out very expressly, very restrictively in an advance directive, then there's not much that the medical professionals can do. Whereas a representation agreement is like a power of attorney, but for your healthcare decisions. So it nominates somebody else to make healthcare decisions for you. In that document, you provide guidance to that person and tell them, under what kind of situations you would say want to do not resuscitate or you wouldn't, or what kind of treatment you'd want. But it allows that person, if there is something that isn't set out in that document, allows them to make a decision based on how they feel you would want it to be made. So it's more dynamic than a static living will that wouldn't change. So again, another good piece to have is your estate planning document. So now I'll pass pass it on to Rick, who's going to talk about dual wills, which I think is something that is probably really, of interest to most people who own shares in a privately held company and real estate in many situations.
Good evening. Yeah, so what I'm going to do is I'm going to talk about two more advanced kind of estate planning techniques. One is the dual wills, and then the second is basically related to trusts. It's alter ego trusts and joint partner trusts. So these are typically situations where you probably have a few more assets than just the regular bear or whatever. You've got a few more monies in your pocket. In other words, you're not saying things like I started out with nothing and I got most of it left. You're not going to be saying things like that. You're going to probably have many millions of dollars. So the first situation is the dual wills. And it's predominantly basically a technique to avoid probate fees. Probate fees are generally a rate, they're a little bit scaled, but they typically are about 1.4% of what's in your estate that is probated. So I often have people come into my office and I talk to them about estate planning, and they are adamant that they do not want to pay any more fees or taxes to the government than what they have to. And they will do virtually anything to basically avoid paying those fees or taxes. I've had people say to me, Rick, I'd rather pay all the money to you that I would pay in taxes to basically do estate planning than to basically pay the money to the government. So it's a pretty hot topic. For people, a lot of people don't understand that assets only really have to be probated if they have to be probated. So, for example, the reason why private company shares are always mentioned in these types of scenarios is that if you look in the articles or the governing documents of companies, they typically say that when a shareholder dies, that it's really the directors of the company that will decide what's needed in order to transfer those shares to an executor and or to an heir. So the companies have a lot of flexibility as to whether or not they need to see probate documents. So what's happened in our business is that people have come up with this idea of basically splitting the estate into two bags. One bag is assets that basically have to be probated. And when I say have to be probated, the only way you can get them transferred out of the name of the deceased is that the person who's in charge of those assets, i.e., like a bank or a land title office or a financial planner or somebody like that, they basically say, well, look, if you don't give us a court order saying that you're the executor of the estate, we're not doing anything. So those are what we call probatable assets. And they're listed out here, things like real estate holdings that are in personal names, bank accounts in personal names, investment portfolios in personal name. Those are kind of probatable assets. But there's another bag of assets that you really don't need to do probate on. And those are things like private company shares, partnership interests. If you've got loans that if a person may have loaned a significant amount of money to somebody and they've got promissory notes and or loan agreements related to that, or really kind of, artwork, things that don't basically have to have some kind of a title transfer that's with respect to a regulatory body. So what people do is they basically divide these into two different bags, and they have two different wills. There is a bit more cost attached to this because first of all, you got to do two wills instead of one. But there are some complications to it because the wills have to be done properly because they have to interact together properly. And there are some rules that you typically have to follow. Like, for example, you've got to have different executors in the two estates because the executors have to basically swear off in some affidavits certain information. And they probably would have to tell a lie if they were executors in both estates. So there are more people involved and there's more documents involved, so it is a little bit more complicated. But if you can save a significant amount of probate fees, and I just had one client who basically had an estate of about $30 million, and he had it split into two different bags. One bag was 24 million, and that was the secondary will, or the secondary estate. So he saved probate fees on that $24 million, or will save it when he ultimately dies. So it can be a significant number. So it's certainly worthwhile to look at. It's typically used by people who are business owners, or people who are involved in companies, and people who own lots of real estate. They're often usually owning this real estate in companies if they're listening to their lawyers and worried about liabilities and so on. So it can be a significant savings. So the second avenue of attack is what we call the alter ego, or the joint spousal trust. So the alter ego, there's the reason why there's two different names here is that it really depends on how many people are involved. If there's only one person, it's an alter ego trust. If it's a husband and wife, then it's a joint spousal trust, so that there's two people who are involved in the trust. Outside of that, it's basically the same regime. So what people find really quite surprising is that these are creatures of the Income Tax Act. So the Income Tax Act actually gives you some benefits here in the fact that they allow these types of trusts so that you can basically save probate fees. And there are a few other benefits that come out of these trusts as well. But the key factor in these things is that either one or both of, well, at least one of the parties involved, one in the joint spousal trust, and of course one person in the alter ego trust, have to be of the age of 65 or older. So it's not available to just everybody. It's got to be used by somebody who's over 65. And what it allows people to do is to set up these trusts, and you basically put whatever assets you want to put in the trust. And you can put all your assets in the trust if you want. And what it allows you to do is to transfer those assets at their cost base. So in other words, you don't incur any tax when you basically transfer these assets, or you gift these assets to the trust. So your trust basically takes those assets at the cost base that you've got on those assets. So the government ultimately gets their tax somewhere down the road, because once the last of the two or one party dies, there will be some taxes that will be payable to the income tax people, but it's delayed for the income tax people. So there are some other benefits other than just basically saving probate fees, because you do save probate fees because when you die, or when the last of the joint spousal trust beneficiaries dies, the assets are split pursuant to whatever it says in the trust. So it doesn't go into your estate, does not need to be probated, does not attract probate fees. So people love that. It also gives a few other benefits as well, because first of all, one thing about the probate process is that it takes time. And people often complain about this, that, it takes months and months and months. You got to deal with regulatory bodies and so on. So there's no probate needed. It's basically much more instantaneous when people die. The last of the two parties dies and the joint spousal trust or the alter ego trust beneficiary dies. It just goes however it is basically outlined in the trust. So the trust almost becomes a bit like a will document. And the other thing that it allows people to do is that because it's not a part of your estate, there's no wills variation action possibilities. If you folks don't know this, there is a provision in WESA that basically says that spouses and or children can basically dispute the results of a will if they don't feel as though they've been dealt with equitably. And that is always a factor if people are trying to cut somebody out of an estate or whatever, it makes it much more difficult to do if you've got to deal with that WESA wills variation action provisions. Well, that doesn't apply to a joint spousal trust or an alter ego trust. So you can basically quite freely do what you want to do. And the other thing with these trusts is that you can basically wind these trusts up anytime you want. So if you change your mind and you decide that you don't want to have the trust any longer, then you can basically say, yeah, look, I'm going to wind it up and I'm going to give all the assets back to whoever gave them to the trust, and we're going to wind this thing up. I actually had one client who he set up a joint spousal trust because he wasn't getting along with one of his kids. And that was the only reason why he set it up. So he set it up and he put all his assets in there. And then about 2 years after he set up the trust, him and his kid are getting along famously. They're going to hockey games together and having a great old time. And he came in one day and says, yeah, I'm just going to wind this thing up. I still think he probably should have kept it because it had some benefits, the other benefits that I'd mentioned here. But in any event, he decided just to wind it up and he was able to do that. So at the end of the day, when it comes to who should be using these, the accountants of the world kind of say, well, look, if you don't have 1.5 to $2 million of assets to kind of put into the trust, probably the administration costs and the setup costs and everything will probably defeat any real benefit that you're going to get from those trusts. So just keep that in mind when you're thinking about whether or not you would use these. So I will pass it back over to Evan.
Thanks, Rick. Unfortunately, this next slide isn't about something that sounds as cool as an alter ego trust. I think the name there sells itself. And just to echo what Rick is saying, there's the alter ego trust is a great tool, especially for high net worth individuals. We've got a client right now that's worth about $5 million, and she's got 4 kids, and one of them is a degenerate gambler, and the other has a bipolar disorder, and she wants to make sure she's taking care of these kids, but she doesn't want them to get a windfall when she passes away. So the alter ego trust works nicely for her because it, she can keep the funds that she wants to set aside for her 2 sons that have difficulties, in trust, and they can't do a wills variation action saying that they didn't get an adequate share. And she's also going to save a whole bunch of probate fees, which justifies the cost of setting up the alter ego trust. So, there's more to it than the cool name, of course. But so just to briefly kind of go over again the incapacity tools that we have. So we've talked about, wills, dual wills, and alter ego trusts, which would take things out of, your estate that would go through your will. And then we've got incapacity planning. So I touched on this a bit earlier, so just to recap, we've got the power of attorney, which is, allowing somebody to make financial and legal decisions for you when you can't make them for yourself. And so again, almost as important to have in place as a will, especially if you own property in your personal name. And it's also handy if if you're just out of the country and you're doing a refinance, or you need somebody to get the mail for you, they can take that power of attorney and potentially help you with your affairs. And the power of attorney ends when you pass away. And then we've got the representation agreement, which is like a power of attorney, but for healthcare decisions. And so you're nominating somebody to make healthcare decisions and personal care decisions for you, which for some people are very significant. It's about whether you get blood transfusions, or whether there's a do not resuscitate, or whether you wish to be resuscitated. Whether it's for personal care decisions, like if you like to go to church, if you like to play bingo, or who knows what, it's somebody that can help make those decisions for you when you can't make them for yourself. So varying degrees of importance for for different people. And typically we do all of these things together as a package. We do the wills or dual wills, alter ego trust, power of attorney, and representation agreement. We generally do it all at once because it makes sense to have a complete plan in place, so that you can have peace of mind. So
Awesome.
that's
I
yeah.
think you've got one more slide here, and that's the wrap up.
Yeah, so I think that typically how we approach these things with clients is um, if you have an estate plan already, like if you have a will or a power of attorney, you know, we're happy to take a look at it. And sometimes we look at wills and powers of attorneys, and we talk to people, and the will that you have in place is just fine. Your power of attorney is fine. We're not out here to sell anybody anything they don't need. But if we can add value, then we will. If somebody doesn't have an estate plan in place, then it's definitely something that we can help deal with. And we work with financial advisors and with accountants very closely because it's not something that, especially when somebody has accumulated wealth through real estate or any other means, it's not something that you can, you want to have done in isolation. You want to have it done right. You want to talk to your accountant, your financial planner, and your mortgage broker as well if there's mortgages or loans on land that are still in place. So you want to have that complete picture there, and you want to have all of your professionals working together. It's definitely something that we can do, and we work with um, other professionals all the time. Yeah, Rick,
Awesome.
any other comments there?
No, I think you've covered it, and we'd be happy to talk to anybody who calls us. We talk to them.
But there's a question in the chat. So alter ego trust at death, who pays the capital gains tax? Is it split between the surviving beneficiaries named in the alter ego trust?
Well, the trust, there's no taxes going in. Like when you contribute or you gift items or assets to the trust, there's no tax at that point in time. So the tax would be paid upon the last of upon death, effectively, right? Unless you're selling assets. So the trust basically operates very similarly to the way people would have operated prior to the trust.
Yeah, and there's a deemed disposition upon death of the primary beneficiary there. So the alter ego trust unfortunately doesn't get rid of capital gains tax.
Yeah.
It helps avoid probate fees, but typically, pursuant to the terms of the trust, the money for capital gains would come, from the trust assets, just like it would from the estate. Um, so there still needs to be a plan put in place for how those would be paid, whether it's life insurance or money set aside or selling assets.
Yeah, awesome. Another question that came up just the other day. I had a client that said, "Oh, well, we have a will set up, and so will this not speed up the process through probate?" And so I guess they were thinking that they wouldn't have to probate anything if they had a will. Maybe just give me an idea of like the process if you do have a will set up. What is the process for you to pass through probate, and how long does that take?
Yeah, so the process is if you have a will, um, relatively straightforward. If your executor is still alive, which, believe it or not, sometimes people don't have executors, they predecease them. So if your executor is still alive, your executor, usually goes and sees a lawyer, and the lawyer will assist you with preparing the probate application to the Supreme Court. The most difficult thing is usually just gathering all the assets and liabilities of the deceased. But once we have that, we can prepare the materials pretty quickly. We have to give notice to beneficiaries and anyone else named under the will and anyone that could challenge the will. And that usually takes a couple of weeks. Once that notice has been given, and we have all and we have all the information about the assets, we can submit an application to the probate registry. We can actually choose any Supreme Court location in BC. And sometimes, we will submit applications to Prince Rupert or Smithers or somewhere, really out there because they're just really they've got a slower or quicker processing time for probate. So yeah, it can take anywhere from a month to 6 months depending on processing time and if the registry has any comments.
Apparently,
But
there's nobody dying in Prince Rupert.
yeah,
That's the place, eh?
That's apparently the
it's
place.
it's too rainy for seniors.
Yeah, yeah. Interesting. Well, who knows? Awesome. Well, thank you. I'm sure what we'll do is that after the presentation is over, which we're almost finished, I'll open up for some more questions if anybody else has any questions. But thanks for giving us all those details. Appreciate that.
Of course.
So I think the biggest keys here is a home is an asset and real estate is an asset, but when you're inheriting property, there's debt inherited with it too. You don't just get the home and not the debt. And so sometimes the issue that you may be passing down to your next generation is, can they afford what you've handed over to them, either with their time, expertise, with the actual dollar amounts. As an example, maybe there's a $1.6 million home with a $650,000 mortgage on it. Maybe the payments on that are $4,500 all in, and the primary earner passes away, and so now the stay-at-home mom is inheriting the property. Now it's there's different schools of thought on like what might be going through that person's head. They might be thinking, well, great, I just inherited $950,000 of equity. The other thought, and frankly, this is probably what people are thinking a bit more when they're going through something as drastic as their spouse passing away, is actually going to be, how am I going to deal with the $4,500 a month payments? And so it's really important to think about the positioning of that, because sometimes I think we, especially as real estate investors, you think about like, just go ahead and sell the property. There's equity in it. Don't worry about it. But I don't think that's what that person is wanting to think about, especially if it's your spouse. First of all, and then second of all, I don't think they're thinking about that equity as much as they're thinking about like, how am I going to manage this payment and how am I going to deal with this property on a moving forward basis. So some of the things that we think about on the mortgage side of things and the finance side of things, there's a few things to think about, because this is one interesting item that comes up, which is right of survivalship. And effectively what happens is when the mortgage is coming up for renewal, or if the bank is notified that somebody has passed away, some lenders are going to say, well, now you need to qualify for that mortgage that already exists. And so the remaining spouse, so in that case, the stay-at-home mom that doesn't have an income, would probably have an issue qualifying for a $650,000 mortgage. And that puts them into a position where they may need to sell the property. And that's not a good position to put somebody into. So that's a major issue or concern. I don't know what happened there. For some reason, it all of a sudden zoomed in. 1 second. Let me see if I can fix that. There we go. So that's obviously an issue. And one of the things that you can do is right of survivorship actually allows you to have the remaining owner of the property be able to maintain the mortgage that's already in place. So if you have two spouses and right of survivorship has been is with that particular lender, then they don't say, oh, well, then now the remaining person has to qualify for that mortgage. It's actually fine that the initial mortgage was already approved with both borrowers, and eliminates the concern or challenge or potential that somebody may need to sell the home if one of the individuals passes away. So not every lender offers this, by the way. Only a certain number of lenders offer it. That's something that we may look at. And we've had clients where we present them different options. And as a mortgage broker, it's important for us to look at this too. If we have clients that are over 65 years old, we've had clients that actually opt for a lender that's a slightly higher mortgage rate, but has right of survivorship, because it's more important for them to know that they're not going to be sticking this spouse in a situation where they might not be able to afford the home. Insurance coverage is a really important one. So this is probably one of the easiest and best ways to financially preserve the estate that's getting passed down. We could have an entire presentation just structured all around the different options as it pertains to insurance. But there's a lot of different insurance options that you could have to set up to protect the mortgage balances and other expenses at death. The cool thing is you can also set up insurance policies inside of your company. And then if anything happens, then the beneficiaries can be individuals. And it's actually really a tax effective strategy of getting money out of a company and into personal hands. And there's even more advanced strategies where you can set up facilities where you have an insurance product. And as you pay into that insurance product, you can actually borrow against the value of the insurance. And then you can do whatever you want with that money that you've just borrowed. So there's a lot of different options on the insurance side of things. And again, they're way more complicated, but if you do want to learn more about the insurance, then I have some contacts that I can connect you with to learn more about how insurance coverage could help you. It's interesting going through this because my wife and I are literally going through the insurance side of things ourselves. And we've decided that, you know what, that's kind of an awkward conversation sitting at the dinner table and thinking about how we're going to set up our home or our life insurance. But I'm getting a life insurance policy, a much larger one for myself, so that then if something happens to me, that she's covered off, and making sure that amount is enough to pay for a mortgage and give her some additional money. And sometimes you don't need it for both parties. You know, I'd be devastated, obviously, if my wife passed away, but financially, I'd probably be okay, and I'd be able to work and pay the bills. And so, you know, it made sense for us to let's make sure that I have the insurance so that if I pass away, that she's covered. And at this point, it's not necessary for me to get her insured because I can afford things if she passes. The other thing that I've heard from all the speakers today is don't wait. Getting this set up before you need it. The strategy needs to be set up before something happens. The lawyers today have discussed that you can't even set up a will if you're incapacitated. So it's really important to not wait. On the financing side specifically, this is a phrase that I've mentioned before, but you always want to get funding when you don't need it, because when you do need it, they're usually not willing to give it to you. So if you lose your job, all of a sudden it's much harder to get a mortgage. Just making sure that you have the right setup in advance is really, really key and important. And the other thing that I've been hearing too, and I mentioned this earlier on some of Christian's points with the stewardship and lack of liquidity in the portfolio, there are some cases where some taxes may be due before any assets are disposed, and that can also create a further lack of liquidity. And so in some cases, we can set things up in advance, but also if there is a need for some short-term funding, we can do it. It's often more expensive. And one of the things that I have found that it can be really difficult, and I've had a couple of scenarios like this where people need the funding before it is past probate, and that is very, very difficult to get approved and done. And so it's important, if you can, to set up the financing in advance so that then as this is passing through and the executor is dealing with everything, there's proper liquidity to be able to handle and run things during that period of time in which you're passing through the probate, and then able to eventually, if needed, dispose of assets. So on the financing side and financial side, I just wanted to bring up these as some of the areas that we as mortgage brokers are thinking about when we're helping somebody with the estate planning. And of course, there's so many other scenarios and considerations here. The obvious one is just making sure that the mortgages are set up the proper way and whatnot. But these are some highlighted items that are a bit more specific to estate planning, particularly. So I'll wrap things up just talking about interest rates. Today we had a Bank of Canada meeting. Bank of Canada has paused interest rates for the 6th time. And so we are finding that there are no changes at this point in time. Let's take a look at the crystal ball and look at where things are expected to head. So this is a quick excerpt that you'll see that in our newsletter that will be emailed tomorrow. But the 5-year outlook for variable rates is looking like short term, so the next 3 months, Bank of Canada is likely to stay flat for the next probably 6 months or so is what's being predicted. So throughout most of 2026, expectation that the Bank of Canada will not change interest rates. However, in the medium term, so we're starting to now stretch things to the 3 to 12 month period, there's more of a likelihood to go up than to go down over the next 12 months. It does sound like any movement would be small, but there is an expectation that we may start to see some hikes heading into at some point in 2027. Long term, there are hikes predicted and projected, and that's mostly due to the inflationary risk and the fact that we're in a position where tariffs are going to have inflationary pressures, and the oil situation because of Iran. We still haven't quite seen the massive impact of it yet, mostly because a lot of countries have been dipping into their oil reserves that they have, and that's creating some artificial supply, so to speak, in the market. And a lot of countries are doing that because they feel that this Iranian situation, well, U.S. and Iran situation, may soon have a recovery. And obviously, we thought we did have a ceasefire, and then all of a sudden, a week ago, oh, never mind, I guess the ceasefire is over. So I'm not surprised that we're going to have this back and forth with regards to this. So it'll be interesting to see what comes out of it. On the fixed rate side of things, you can see that all the arrows are up. Unfortunately, we were seeing that rates were starting to settle down in the short term anyways. The bond market was starting to reach around 3%, and then the ceasefire, and all of a sudden, within 5 days or so, the bond market had gone up by 0.2%. It wasn't enough to set off the majority of lenders to increase interest rates, but at least took off the table the prospect of maybe some slight rate decreases in the short term. In the medium term, the war in Iran is causing inflation, and that will cause fixed rates to increase even if it ends tomorrow. And so the medium term is still projecting interest rate increases. And in the long term, they're still projecting that the rates will rise by about 0.1 to 0.2% per year long term due to the inflationary effects of mostly the tariffs and now, of course, most recently because of the oil situation. So unfortunately, expecting rates to go up. But looking at the forecast here on fixed and variable and where things are looking like they're heading, this is what the professional bettors that are trying to peg something in the future, and of course we don't know how accurate this will be, take note of the best 5-year fixed rate around 4.24 today, but then looking at where that might be in 1 year from now, going all the way up to 4.91%. And this is a pretty big jump up that we're seeing, and this is mostly starting to get adjusted because of the situation that we're dealing with in Iran with the ceasefire. And then you can see that rates start to increase about 0.1-ish% per year ongoing after that. And you can also see that they're predicting within 12 months that the prime rate will have jumped up a fair bit as well. And so they're expecting 3 hikes by within 12 months. Most of the hikes are being predicted sometime in 2027, with 1 or 2 hikes in the first half of 2027, and then another one later in 2027. So again, nobody really knows where things are going to go. Obviously, the kicker here, and the thing that people aren't really sure of, is, well, if the tariffs are really, really negative, and or if CUSMA, the international agreement, or I should say agreement between Canada, the U.S., and Mexico, if that gets torn up by the U.S., we might see that Canada's economy goes into a tailspin, and that could cause interest rates to drop, or at least not to rise, to combat lower expected growth. And so we're really keeping our eyes on that. That's probably the other than the situation in Iran, that's probably the one key thing that would have the largest impact on interest rates moving forward. So if I look at our lock-in meter, how, if you're in a variable rate right now, should you be looking at locking in? It is a 7 out of 10 to lock in at this moment. It's high, but it's not like you must lock in 100%. If you are in a situation where your discount off of prime is not really good, then it makes more sense to lock in. If you have a really deep discount like prime -1 or something, then it may not make as much sense. We are finding that the pendulum has swung, and so 3-year fixed, 5-year fixed, and the 5-year variable, the 3 most commonly chosen terms by a large mile there. All 3 of those are predicting to be really close to the same amount of interest over the next 5 years. So it's not clear to us right now that, oh, there's a clear winner. And if you asked me 2 months ago, the 5-year fixed, or 3 months ago, the 5-year fixed looked like a clear winner. And then for a little while, when the ceasefire happened, actually variables started to look a little bit better. Now the ceasefire has stopped, and now it's not looking, better. It's looking about the same as the other terms, which means that choosing the right term is becoming more of a personal decision. Do you think that you might sell the property or make a large, significant payments on it in the next short term? Maybe a variable is better. If you're thinking that you really want safety and maybe you're a first-time home buyer, maybe a 5-year fix is better. So I do think it's a bit of a personal decision right now. So if you do want to get an idea, even if you're renewing your mortgage and you just want a quick analysis on like which term should you choose, feel free to reach out to us and we can help with that. And then of course, like Christian, I'm also an author too. Wrote a book called Rockstar Real Estate Investing. Many of you that are here, I know most of you, and you probably have a copy already. But if you don't, let us know, and we'd be happy to put a copy of the book in the mail for you. And then, of course, happy to chat if you have any questions. So I'll stop the share at this point, and then what I'll do is I'll open it up for any questions. So if anybody has any questions for us and you'd like to just chat, pick our brains about anything, then please let us know. I see Mura also mentioned the U.S. midterm elections also around the corner. Yeah, there's lots going on right now. Lots going on. I was happy to see that the number of attendees stayed the same the whole way through, even when the lawyers were talking. Everybody's paying attention, which is great.
Must be a good crowd.
They hate those lawyers, don't you?
Yeah, I mean, you don't usually call up your lawyer because you have something fun and exciting to talk about, unfortunately, right? So,
Yeah.
It's worse when they call you.
Yeah. Yeah.
Well,
Yeah.
and you're right, Kyle. Like even the life insurance is awkward, and even the will conversation is awkward because we're talking about what happens when you die, right? And it's it is usually starts out as something that is a little weird, but it's certainly a gift that you give to those that you leave behind.
I can still say that the popularity of lawyers has not fallen below insurance agents yet. So we're hanging in there.
Yeah. That's awesome. So far, I haven't seen any questions. So obviously, all of these individuals would be happy to share their time with you if you do have further questions, and hopefully you're able to grab their contact information. And so maybe we'll wrap up the meeting now. But thanks so much for taking time out of your evening, guys. This was really valuable information. And we will be sending the recording out to all of the registered guests. So anybody that registered for this will be receiving a copy of the video so that you can watch it later. There is one quick question that came in the chat. Do the lawyers do agreements for disabled dependents?
Yes.
Like a Henson trust, I think is one of what they're kind of commonly called, but definitely, yeah.
Yeah, perfect. Okay, awesome. Well, thanks so much, everybody. Thanks for coming out. I hope this was informative and valuable to you all, and look forward to seeing you all soon.
Thanks, Kyle. Thanks,
Good
everyone.
night.
Bye now.